there, it's Carol Morrock at carolmorrock.com. Welcome to Soloing Smart. And today is my special guest, Wendy Whiteman. And she's going to help us address some of the issues that solo agers really face when they're aging alone without family members. And Wendy began her legal career as a prosecutor at the Dallas County District Attorney's Office, which I think is very interesting. And she is now focusing on elder law. And Wendy is the recent author of Creative Caregiving and Beyond. And she bases her personal experiences of caring for her mother, as well as her practice in the area of elder law. And she hosts the popular podcast, Creative Caregiving and Beyond, which airs on YouTube, iTunes, Amazon, Alexa, and more. So welcome, Wendy. Thank you for joining us.
Thank you for having me, Carol.
This is such an important topic for solo agers.
Yes.
Of course, solo aging really has a whole plethora of issues that we have to address, such
Yes.
as our health, our location where we live, our housing, having social engagements, and legal and financial matters, I think, are one of the top concerns, or those two are their top concerns. Because if we don't have our finances in order, it's really hard to have housing and have good health care. And then with legal matters, we want to make sure that our wishes are carried out, especially the older we get, and because we don't have anyone looking out for us.
Right.
And the topic of legal concerns have always been probably the most talked about issue in our group, the Elder Orphan Facebook group. And, people are always asking, well, who do I select for my healthcare proxy, my financial proxy? How do I know whether or not someone or whoever I select will stand in for me? So thank you for helping us out with this. I'm very excited about you being here. And I have several questions that my group members have asked. But let's start out kind of looking at solo aging as a whole in your eyes, through the eyes of an attorney, because I know you have had clients that are in this type of circumstance.
Yes.
So how do you, so kind of as an overview, just give us a general overview, in your opinion, how we should view our legal issues.
Okay. Well, I think your viewers are definitely on the right track in trying to determine what the best course of action would be. One of the hardest questions I have with all clients, and not just aging alone, is who do they trust? Who will be the person in charge if they need to have someone step in at some point? And I think today is a little different than we've had in previous decades, because people are a little bit more distant, a little bit more isolated. Families aren't as close as they used to be. And so it's kind of hard to find someone. And I do have several clients that are, that were aging alone and had to make that appointment, had to find someone to be their power of attorney, their medical power of attorney, and hash those issues out. Now, those are pretty inexpensive documents overall, no doubt about it. But without them, it can become a huge, expensive legal battle when those things are not in place. So if you weigh the difference from, second guessing yourself in an era to get the right person versus not having it at all. I think it's just better to have someone. And that person, I always say with the financial power of attorney, you want to look at someone who is pretty astute as far as their reliability, they're dependable, they can, they handle their business pretty well. They're not like delinquent in paying their bills, and they are, they're pretty standard. So you want to get someone like that. And that can be, if you don't have family members, I have clients that have chosen their CPA, their pastor, or member of their church congregation that they formed an alliance with, or someone in their bridge club, or someone in their bridge club's daughter. They may have friends that have children. So I've had clients, some of their friends' children stand in for them too, and become their power of attorney, or financial or medical. So there are, if we just kind of start thinking about it, and sometimes you have friends and they mention, or you may have the opportunity to be around their children and see if they're responsible and how they react with their parents, and you'd be surprised at those who are willing to come in and help. I've had several power of attorneys that were not related to the person. And in one particular situation, there was a neighbor that came in and was the power of attorney for the neighbor's son. The parents had passed away. And the mother had aged a bit, and she got too old to really deal with it anymore. So her daughter came in as a good Samaritan and became the power of attorney for that neighbor's son. So it endured to the next generation. And she made sure he got the health care he needed until he passed away. So that was like a generational thing on both sides, just being a good neighbor, just being a good neighbor. Now, that's a rare person, that will take the time out to do that, but they cared about it, and she did it. So it's a serious decision, but it's just one that has to be made, and it can always be changed. So once you make a financial power of attorney, you get the document done, you've decided on someone, your CPA, your church member, or a friend's daughter or son, or someone like that, then you can, if you decide you want someone else, you can always change it by creating another financial power of attorney. You can always add a successor to that. And so if you're in doubt about two people, you can have a successor person. And sometimes I draft it where there's a co-agent. There are two people that are working together. Now, that's kind of tricky because you got to make sure that they will actually work together and they don't run into gridlock and then nothing's done. So I usually advise that you select people that have had a history of working together, or at least know each other, and you think their personalities would fit if they're going to be co-agents.
Yeah. I really promote creating a team
Yes.
of support.
Yes.
Now, that team of support either could be your friend, a neighbor, could be a niece or a nephew. But to me, it seems like a team of people that's looking out for you is better than just one or two.
Yes.
And that way, that, and of course, you want to have the conversation with all of them together in the same room before you even put them put them in the paperwork. You want to make sure they're all on the same page. And there are a lot of websites that give you kind of instructions on how to have those conversations.
Yes.
And which I think is very important. So I'm going to ask you a few questions that some members are curious about, and there are quite a few here. So let's get started.
Okay.
And I know these are some of the common ones that I see all the time. So number one is how to select a person to represent you for a medical directive and finances when you don't have a trustworthy relative or someone close to you and have no family. However, I know we just kind of talked about that. So I think the key here is trustworthy person.
Yes.
You know, how do you, to me, that would mean how do you really research and interview someone or find someone who is trustworthy that will stand for your wishes.
Right, right. And I really think that's part of the observational process that you'll have to do, when you're looking at someone, and just see if they actually do what they say, and they're reliable, their reputation in the community, and you should know them by their fruit. So I would say, definitely observe them and see how they act. And backing up to the conversation, that was a very good point that you pointed out too, Carrie. Having that conversation with everyone as a team, that's so important, because you get a chance to relate to them how you see things, because they're your agent, they're your representative, and so they're to act in a way that you would act. And that gives them that opportunity to know how you think, because you may think differently, and how to do that. And so when the whole team is on that same wavelength, then they can keep each other on track. And so I just think that's a very good point that you made.
Yeah, and maybe even come up with some questions that, and these would be personal questions that really have value to you in terms of what does it mean to you to have someone stand in? What does that mean to you to have someone make a decision that is so significant? And then, and explain those, kind of explain yourself to those individuals that perhaps, or maybe are potentially will become your proxies.
Yes.
I think it's just something we have to really think about. I don't think it's something we do willy-nilly.
No, not at all. And you really want to do it while you're calm, and it's not a crisis situation. I also, as I work in elder law, I see people in crisis. And so 80% of my clients are at that point. And it's difficult when I have a client that is about to make that appointment, and they're trying to figure out who to do it, who to give that appointment to. And so you really want to do it while you're calm. There's not a crisis situation looming around you, and you can make, better choices. Right. So you're right. You just want to take your time and do it, but don't take forever. I had one situation where a client, for 3 or 4 years, they were really skittish about, and they were not aging alone, but they were skittish about selecting an agent, executor, you name it. And so they didn't. And they kept changing it. They kept going over the scenario. We had the conversation 1,000 times. And I said, just select somebody. You've got to select someone. And they finally, they didn't do it. They ended up passing away, and now it's in court. So it's just, you've got to, it may not be the perfect situation that you're thinking of in your head, but at least you've got some control, because you relinquish all control when you don't make a decision. Is like making a decision. So you do want to, be prudent about it, but really, look at it and try to make a decision at some point.
Oh, you have to. Before it's an emergency. That's for
sure. Yes.
A good question came, how do you select an emergency contact? Because the doctor's offices always require to have an emergency contact on the paperwork. And so that's probably a little bit different than asking someone to be your proxy, do you think? Or do you think you would use the same strategy as an emergency contact?
Well, again, with the emergency, you want someone who can be contacted. And so you don't want to get people that are hard to contact. You call them and it takes them 3 weeks to get back with you, consistently.
Right.
But it's not as severe as appointing a power of attorney. So you could use someone from your church or someone from a organization, and just leave them instructions. If this happens, then contact these other people. But I just need someone local. If something happened, they would know who to get in contact with, who could get the ball rolling.
Yeah.
So, but that's important as well. Yes.
Yeah. Okay. Thank you.
Uh-huh.
This other lady asked, my attorney is my financial power of attorney, and I don't have a family to do this for me. Is this a good idea?
Well, I mean, you can. I personally don't endeavor to do that. It's a conflict of interest as I see it. But I mean, some attorneys can do it and still keep those boundaries very clear. But and I've been asked before, and I just steer away from it. I would again examine who, if there are any other potential people, and you could also do a co-power of attorney with that attorney, just to make sure that a co-agent, and just to have a second set of eyes there. That's not a bad idea as well. And so there are a lot of different things to consider. How long have you known them? What is their reputation in dealing with you and other people? Things like that. And so, you want to, if it's someone you've known for a very long time, and you know who they are, their family, you know them very well, then that's not a problem. But if it's someone you've just recently met, and you don't know a whole lot about them, then yeah, I would definitely look at getting a co-agent or someone there as well.
Yeah, and again, I stress having a team, making a team approach.
Yes.
And to add to that, she's asking, is it better to hire a fiduciary as a power of attorney for finances?
Well, you can, and you can also set up what we call in estate planning, their trust that you can set up, and then you can appoint a corporate trustee. That's one way to do it as well. A lot of banks have trust departments where they will actually, by committee, make decisions regarding your trust. And the key is, in those situations, be very explicit on how you want that to operate, because they're going to go by the parameters of the trust, the verbiage in that trust. And so if it's vague, then there are a lot of terms called the trustees, like the trustees discretion. So the trustee will use discretion where it doesn't specifically say so sometimes. And you just want to make sure they think the way you think, and make sure that it's airtight. I've had clients that have had corporate trustees and it's worked out okay. Then I've had clients that have had corporate trustees and it's not been a great situation at all. And they've held assets in limbo. I had one client that, actually she wasn't a client, but she approached me to help, her negotiate the release of the assets in the trust. And the actual bank that was the trustee for it wouldn't release it. And her dad set up a trust and she couldn't get the assets until she was 65. And she worked in an industry that prohibited her from working in the United States at the time. And she'd have to go abroad to actually pursue what she knew how to do. And so she worked in the oil industry. And so she couldn't make a living here. And she didn't want to, move to a foreign country. And so we had to petition the corporate trust department to relinquish those assets. I mean, she was around like 62. And I'd never heard that length of time before a person who created a trust would require the trust to be in existence that long before the person gets the assets. But her dad, I guess he had a sense of humor there. But so they ended up letting the assets go so she could, take hold of the assets. and receive them and not have to go to a foreign country. So, but again, that trust department, they didn't know her. It's not a personal relationship, and they're representing the letter of that document. And so sometimes that can be, depending on the people, they're looking at their liability too. They want to make sure they're not violating any provisions whatsoever. And sometimes that can go in your favor and sometimes it can't.
Yeah, so the point being is be very, very clear.
Yes.
On the details and what
Yes.
you want drawn up.
Yes.
And how you want to distribute it.
Exactly. Yes.
Okay. And here's one that says, if I don't have any changes to my trust, but want to add or delete a successor trustee, can this be done as an amendment without my attorney and have it notarized?
Well, I always suggest that you use an attorney when you're dealing with legal documents, just simply because you've got too much at stake. I mean, one little mistake and it's not valid, and a material mistake, and it's just not worth it. I mean, you can amend a trust, and I'm sure usually that's not that expensive to do that for something that small, and you can get that done. But I would always recommend using an attorney just to make sure it's done right and it's not creates a situation where that entire amendment is invalid. So I would definitely recommend that.
Okay, even when you change the executor, anytime you're changing anything in your will or any type of legal doc or trust, always go through and work with your attorney to make sure you're doing it correctly. Exactly.
Yes, and or at least have the advice of an attorney to take a look at it or something, because yes.
Okay. All right. So can you explain trust versus will? What's the criteria for one versus the other?
Okay. A will basically is a testamentary. It's a document that basically says that, and we all know what it really is, but it defines who would be your beneficiaries in the situation that you passed away. A will has to be probated in court. So for that title transfer to take place to your heirs, you have to actually go to court, and then the court will render an order, appoint an executor, and then give an order for the actual distribution to your heirs. And so with a trust, conversely, you appoint a trustee, and the trustee, upon the termination of the trust, makes the distributions for you without having to go to court. And if it runs smoothly, that's exactly how it should be. And so one situation for those distributions and that title transfer on the accounts and the assets to happen, with the will, you have to go to court. Generally, with the trust, you do not. So that's the big difference. The will is made public record. An inventory of the assets are filed. It's public record. People could see that. The trust, it's private. So they could literally, your trustee could sit at the kitchen table and write checks or make distributions to your beneficiaries in private. So there are a lot of, I really do like trusts. I think in the long run, they're simpler and there's easy to do without, having to go to court.
Okay. Yeah, and so which kind of reminds me, when you go to probate, does it cost like $1,500?
It can, and it can cost a lot more than that, depending on the case, and if it's contested, if there's a will, if the will is valid. If there's not a will, they may have to do a determination hearing, heirship hearing. So there are a lot of factors, and people can come in and contest it. So, which always drives up the cost as well as the time. And, the courts are pretty backlogged right now, and you just don't know. I litigated for over 10 years, and you don't know how things are going to turn out. it's really interesting how things can turn out in court. Whereas with the trust, I think you have more control. You can really dictate by the boundaries of the wording in the trust, how you want things to be distributed and who you want them to go to. Yeah.
Okay. Now, however, if you have beneficiaries set up on all your accounts and your assets, does that bypass going to probate?
That should, yes.
Okay.
If working perfectly, yes, that should bypass having to go to probate. And I always tell clients to, when you have that set up in accounts, just double check it, have the bank or the financial institution send you confirmation on their letterhead who your beneficiaries are or your payable on debt people that are named, and keep that with your estate planning documents, because there are times where a bank has been bought out or data entry doesn't get transferred to the next, and that's not there. So I just, I recommend that they just have a second confirmation that they are actually on that account.
Okay, thanks. Thank you. Because that's what my attorney had told me. However, I just wanted to clarify that.
Yes, that is correct. Yes.
I have a question that says, how do I make sure the directives for my dogs, my pets, are followed? How do I make sure a legally adopted child has no inheritance to any of my estate? So it sounds like she wants to leave her assets to her pets, and she does not want her adopted child to contest it.
Okay. Well, there are what they call pet trusts, where you can appoint a trustee to take care of your pet and leave assets available for your pet. And so that is possible. You can do that. Within the instance of the adopted child, well, in Texas, an adopted child has the same inheritance rights as a biological child. So you would have to specifically disinherit that child in your will, and use that specific language to do that and make it very clear. You can't do it, but you would have to disinherit them and make sure it's in your will. Yeah.
Okay. Thank you. Yeah, that really clears that up. I get that. Yeah.
Yes. Okay.
Another person's asked or states that she lives in a community property state, and she's the named executor of her husband's will. Everything we have is in both our names: mortgage, cars, bank accounts, etc. And she's been paying on everything as usual. And she wants to know, do I need to do something else, like file the will with someone else or let the various companies know when he dies?
Yeah, yes. Yeah. Since she's the executor and everything's in both of their names, it shouldn't be a problem. And I will say that, bank accounts can have, a couple of ways they could be titled. They could be joint with right of survivorship, or joint in tenancy in common. And so with the tenancy in common, and sometimes you find that in different states, I'm not sure what state she's in, then half is hers and half is her husband's. And if there's not a POD, then that could be an issue. So again, I would just be very clear as to how the scenario works out if one of you died, and have that conversation with the bank and make sure you have the proper POD on, there, as well as, with the mortgage company, if it's a community property state in Texas, for instance, his share still doesn't automatically go to you as a wife. You still have to link that together, basically, that inheritance through probate as well. And so you just want to, you have to be kind of prepared for that. since it is community property, because he could leave that share of his community property to anyone he wants to. And so, but you do have to make sure that's done through affidavits of heirship or probate, depending on the length of time, from the death. But I think you're definitely on a good start. That both your names on all the accounts, and that surely does make it easier with the companies and dealing with them later on, for sure.
Okay. Yeah. That's interesting. So the bottom line is talk with an attorney.
Yes. Talk with an attorney. Again, I guess I should make a disclaimer. This is not legal advice. I'm not giving you specific advice. I would definitely advise everyone to speak with an attorney, but this will just maybe point you in the right direction to an attorney and give you an idea and how to have that conversation. But like the book I wrote in my podcast, Creative Caregiving, this whole process is creative, and it's what you make. Just keeping that in mind. And so it can go whatever way you want it to go, but you have to at least know what direction you want it to go in. And that's what this conversation and this podcast Carol is putting together is about today. It's just knowing what are your options. Yes.
Yeah, right. Yeah, and I really encourage everyone to speak with an attorney.
Yes.
Because you have a lot of options. Just get clear on what they are, and then do your own due diligence and really a deep dive into your own value system, and
Yes.
To get clear on what it is. What are your wishes? How do you want them fulfilled?
That's so true.
That's so important. And then I'd like to end it with, because this is something that I'm going through myself, is selecting a professional certified fiduciary, because I've heard bad news, good news. So, for example, you as an estate attorney or elder law attorney, you work with fiduciaries. I'm not asking you to recommend anyone, however, but you have the capacity, I guess, as an attorney to recommend fiduciaries that you've worked with before.
Yes.
Okay.
And that's a good point. Just like anything else, I mean, referrals are usually the best way of doing business, and getting those referrals and references from people that have used them, as well as references. Ask them, even if it's a big company, ask them, I want references. I want people that you've dealt with that were satisfied clients, and you really represented their interests. So I think that's always the best way to go, is just get those references and referrals. Just ask around, and you'd be amazed on how people are so willing to help, because they've been through it. They know someone who has been through it. They know how difficult it can be when you don't know. So, but yeah, you could ask an attorney for a reference for a professional fiduciary, and your bank, your investment advisor. They may have a department in their company. I think that's a good start.
Yeah. Unfortunately, there's not a lot of information and guidelines and help and strategies that we can even do research on to find how do you do this. So we're all kind of putting together, piecemealing it ourselves.
Yes.
And so again, everyone, please speak with an attorney, because this is very, very important, especially if you have assets and if you have beneficiaries, and to make sure that everything that you want to happen really does follow through and carry out according to how you want it to. So
that's true.
Just do your due diligence, ask around, because this isn't easy, and just know that this isn't also, it's not a once and done deal, because things change.
Yes.
They always do. When you think you have it put together, life always is a wrench.
That's so true. That is so true.
go. Well, thank you, Wendy. Thank you, listeners. I hope this gives you some, kind of gives you a roadmap and a way to kind of prompt different ways to think through, creative ways to think through how to address your legal issues. And Wendy, thank you so much for your time.
Thank you for having me. I really enjoyed it.